Pleasant day, everyone. I am Zenaida Bantilan, and today we're going to discuss the chapter 5 of our legal aspect in tourism and hospitality, which is the law on sales, agency, and credit transaction. At the end of this discussion, we will be able to describe and explain the nature of sales transactions and identify the function and operation of agency in the industry, and lastly, we will be able to identify ways of handling credit transactions. Law on contract. In tourism and travel and hospitality industry, agreements arising from contracts will have to be made, and potential breaches from these agreements will be encountered. A contract of sale is one of the usual contracts being encountered by the industry concerned. This will give us an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. So now let's move on to the Article 1458, which states that by the contract of sale, one of the contracting parties obligates himself to transfer ownership of and to deliver a determinate thing and other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. Now we're going to discuss about the characteristics of a contract of sale. The first one is that it is consensual because a contract of sale is perfected by a mere consent. No form is prescribed for the perfection in a contract of sale except those covered under the statute of fraud. And if the sale of the real property is made through an agent. Another characteristic is that it is bilateral because it gives rise to reciprocal obligation. The third characteristic of it is principal because it can stand by itself without the need of another contract. The fourth one is unirus because the consideration for each party is the delivery of the thing or the payment of the price. The fifth characteristic of is it commutative because the vendor or seller delivers is considered equivalent of the price paid by the vendee or the buyer. And then the next one is that it is nominate because it has a designated name under the Civil Code of the Philippines, which is sale. And lastly, it is transmissive of ownership because the vendor transfers ownership of the subject matter to the vendee. Requisites of a contract of sale. First is consent. Consent is manifested as a meeting of offer and the acceptance upon the thing and the cost which are to constitute the contract. And here are the disqualified to enter into a contract. A are the husband and wife. A sale between husband and wife in violation of Article 1490 is inexistent and void from the beginning because such contract is expressly prohibited by the law. And B, and here are the following persons cannot acquire by purchasing even at public auction or judicial auction either in person or through the mitigation of another. First is the guardian. They cannot purchase the property of the person or persons who may be under their care. And agents, they cannot purchase the property whose administration or sale may have been entrusted to them unless the consent of the principal has been given. Now, executors and administration, they cannot purchase the property of the state under administration. And public officers and employees, they cannot purchase the property of the state or any of the subdivision thereof or of any government owned or controlled corporation or institution, the administration of which has been entrusted to them. Now, justices and judge, prosecuting attorney, clerks of superiors and inferior courts, and other officers and employees connected with the administration of justice cannot purchase the property and rights in litigation or leave it upon on execution before the court within whose jurisdiction or territory they exercise their respective function and others, and lastly any other specific qualification disqualification by law. So any contract entered in violation of the above mentioned are shall be rendered the contract void by the reason of public policy and because such contracts are also expressly prohibited by law. Effect of loss of the object in contract of sale. Under Article 1480, any injury to or benefit from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of the delivery shall be governed by Article 1262. And under Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. Under Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the way specified in Article 1497 to 1500 or any other manners signifying an agreement that the possession is transferred from the vendor to the vendee. Now, it states here that if the thing is lost before perfection to the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res domino. And if the thing is lost at the time of the perfection of the contract shall be considered without any effect. And if the thing is lost after delivery, the buyer shall bear the risk loss since delivery transfers ownership. The principle of risperot domino. If the thing is lost after the perfection by before delivery, the seller bears the loss since the delivery yet hence no transfer of ownership to the buyer. It is possible that in buying personal properties used for public transportation or delivery of goods, this provision will be useful for the contracting properties in case of sale of personal properties payable in installment. And for 84 that states in a contract of sale of personal property, the price of which is payable in installment, the vendor may exercise any of the following remedies. First is exact fulfillment of the obligation should the vendee fail to pay. Two is to cancel the sale should the vendee's failure to pay cover two or more installment. Third is to foreclose the chattel mortgage on the thing sold if one has been constituted. Should the vendee's failure to pay cover two or more installments, in this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. So, in order for the above provision to apply, the following requisite must be concurred. First is the contract must be of sale. And second is what is sold is personal property. And third is that the sale must be on an installment plan. If the sale is for cash or on straight term, Article 1484 does not apply. About double sale. Caution should be practiced by real estate developers engaging in the hotel industry, especially on real property located in potential yet unexplored provinces. The principles on double sale will be useful in case an issue on a sale of a real property to different vendees shall be brought before the court of law. So, based on Article 1544, it stated there that if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession in good faith, if it should be movable property. Should it be movable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was the first in the possession, and in the absence therefore to the person who presents the oldest title provided there in good faith. So based on the above provision, the same property which has been sold to different buyers or vendees in case an immovable property covered under the torrent's title is sold to different vendees, the one who is the first registrant in good faith at the registry of deeds where the property is located shall be preferred. The pacto directo sale or conventional redemption. Based on Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold with the obligation to comply with the provision of Article 1616 and other stipulation which may have been agreed upon. So, as between an absolute sale and the sale with the right to repurchase, no difference exists except that in the latter, the ownership of the purchaser is subjected to the resolutory condition that the vendor exercises right to repurchase within the time agreed upon. Obligations of the vendors. Under Article 1495, the vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sales. Under Article 1496, the ownership of the thing sold is acquired by the vendor from the moment it is delivered to him. And under Article 1497, the thing sold shall be understood as delivered when it is placed in the control and possession of the vendor. So, under the said provisions, the obligations of the vendors are first, to deliver the thing, second is to transfer ownership of the thing, and third is to warrant against eviction and hidden if defects. Delivery is a mode of acquiring domination and determines the transmission of ownership and the birth of the right of a real right. Warranty in case of eviction is an implied warranty in contract of sale by virtue of which if the vendee is deprived of the whole or a part of the thing purchased by final judgment based on the right prior to the sale or an act imputable to the vendor, such vendor shall answer to the eviction even though nothing has been said in the contract on the subject. Warranty against hidden defect. A defect is considered derogatory if it is hidden, unknown to the buyer, existing prior to the sale, at least in origin, and which render the thing unfit for the use intended. Obligations of the vendee. Under Article 1582, the vendee is bound to accept delivery and pay the price of the thing sold at the time and place stipulated in the contract. And here are the action for breach of contract of sale. Extrajudicial remedies. One of the buyer. A. The buyer need not pay unless there is delivery. B. The buyer may reject improper deliveries. C. The buyer may suspend payment if he is disturbed in the possession or ownership of the thing or has reasonable ground to fear such disturbance. 2. Of the seller. Vendor is not bound to deliver the thing sold if the vendee has not paid the price. B. Installment sale. Recto and Masida law. Judicial remedies. One of the buyer. A. Damages for breach of contract. And two of the seller. A is recovery of the price and B is damages in case of bad faith. Law on agencies. Now, under Article 1868, by the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. A contract of agency is a relation in which one person, the agent, acts on behalf of another with the authority of the latter, the principal. It is a fiduciary relationship which results from the manifestation of consent by one person that another shall act on the former's behalf and subject to his control with consent by the other so to act. The act of the agent will be binding on his principal. The essential elements of agency are first, there is consent expressed or implied. Second, the object is the execution of an judicial act in relation to a third person. Third, the agent acts as a representative and not for himself. And fourth, the agent acts within the scope of his authority. Ability of the principal and the agent. Under Article 1883, if an agent acts in his own name, the principal has no right of action against the person with whom the agent has contracted. Neither have such person against the principal. In such case, the agent is the one directly bound in favor of the person with whom he has contracted, as if the transaction were his own, except when the contract involved things belonging to the principal. Now let's move on the law on credit transaction. Based on Article 1933, by the contract of loan, one of the parties delivers to another either something not consumable so that the latter may use the same for a certain time in return, in which case the contract is called accommodatum, or money or other consumable things upon the condition that the same amount of the same kinds and quality shall be paid, in which case the contract is simply called loan or motum. Comodatum is essentially gratuitous. Simple loan may be gratuitous or may stipulate to pay interest. Simple loan or motum. Under Article 1956, no interest shall be due unless it has been expressly stipulated in writing. In a contract of loan, if a particular rate of interest has been expressly stipulated with the parties, such stipulated interest shall be applied. If the exact rate of interest is not mentioned, the legal rate shall be payable, which is 12% per annum under Section 1 of the Usury Law. Pactum Commissorium. Article 2088, the creditor cannot appropriate the things given by way of pledge or mortgage or dispose of them. Any stipulation to contrary is null and void. Pactum commissorium is defined as a stipulation giving power to the creditor to automatically appropriate the things given as security if the principal obligation is not fulfilled without any formality, such foreclosure proceeding and public sale. And that ends our discussion.